Good morning. Can you hear me?
Good morning, sir.
Thank you. All right. एक second जरा. Supposing normal रखना है सिर्फ शेयर की हिसाब से. Just about the slide PDF. All right. Today in this session, we shall be talking about the rights of proprietors and the Gram Panchayat in the village common lands, which may be Shamlat and which may be Jumla Malkan lands. So in both the types of land, what are the precise rights of the proprietors and the Gram Panchayat? And that is one aspect. Second is what is the civil court jurisdiction, because that is the point issue with which we'll be mainly concerned. What kind of matters can come before the civil court, and what kind of relief the civil court can grant in relation to Shamlat lands and the Jumla lands. Then thirdly, other matters which I have known come to the civil court is regarding the change of user. Sometimes the people come and file civil suits saying that the Gram Panchayat is changing the user of Jumla land. For example, in the Jamabandi, it is recorded, some purpose is recorded that this land is to be used for this purpose. And the Gram Panchayat passes a resolution changing the user, land use. Can you give injunction? Or is it permissible for the Gram Panchayat to make a change of user? So this also is another aspect. One more aspect that we'll be going into is when these Shamlat and Jumla lands vest in the municipal committee, they are included within the municipal limits. Then what happens to such lands? And what right municipality has in such lands? Or whether those lands revert back to the owners, that is another question with which you'll be faced. So now we can start. Slate. So now the questions which I have talked about is one. Rights of Gram Panchayat and proprietors in Shamla and Jumla lands. This is the question number one. Now, first of all, let us see what is the distinction between Shamla and Jumla lands. Now, the Shamla land is the village common land, which was existing prior to the consolidation of holdings. This exists right from the day the village is founded. Some part of the land in the village is reserved for common purposes. That was known as Shamlat land. This is the village common land prior to the consolidation of holdings was taken up in the village. Now, in the revenue records, this Shamlat land was described as Shamlat De Hasab Rasad Zare Kevat or Rakba Kevat. Now, this meant that the proprietors of the village, the Kevatdars of the village, had a share in the Shamla in proportion to their rights in the Kevat. The bigger the owner, he'll have a larger share in the Shamla. That was the meaning of this term. But then in the year 1953, Punjab and Pepsu, both of them passed legislations vesting this land in the Gram Panchayat. That started in 1953. Thereafter, 1961 Act was passed with some modifications. The land continued to vest in the Panchayat, which had vested in 53 with certain modifications. And because you also know that in 1956, this Pepsu area also merged in the state of Punjab. So the 1961 Act was passed. This was for the Pepsu and Punjab both. And under this act, the entire Shamla they stood vested in the Gram Panchayat. This ownership vested in the Gram Panchayat. So this is the Shamla. Thereafter, consolidation of holdings took place in the villages in the 1950s and 60s. So during consolidation, where it was felt that the land reserved for common purposes in the village was not adequate for the requirements of the villagers, they provided for the additional common lands. Now, this was done by making pro rata cut in the holdings of the proprietors. Now, a land pool was created by making a pro rata cut in the holdings of the proprietors. Now, this land, which was created by making this pro rata cut in the revenue record, was described as Jumla Malkan va Digar Hakdaran Hasab Rasat Rakba. So this was the description given to these Jumla Malkan lands. And the meaning, this term meant that the proprietors continue to be the owners of the land in proportion to their share in proportion to their share which they had in the their kevod. But the management and control of these lands vested in the Gram Panchayat. That was the original scheme. Management and control of these lands vested in Gram Panchayat. Only the management control, the proprietary rights kept on vesting in the proprietary body. Now thereafter, the decision which I'll be dealing with is the Supreme Court decision in CA number 6990 of 2014. This is State of Haryana versus Jaising. This is the recent decision by the Honorable Supreme Court. This is decided on 7th of April 2022. Now, this decision, in fact, has made a large number of changes in the existing legal position and has clarified many points on which there was earlier doubts and confusions. So what is the precise holding of the decision on all the relevant points? That is what I want you to know in this session. Now, in this decision, the Honorable Supreme Court has categorized the village common lands into three separate categories. One is Shamla, properly so called. That is, you have already seen the village common land as it existed since the foundation of the village. Two, this Jumla land is of two types, according to the Honorable Supreme Court. This Jumla land is of two types. One, which has been taken from the proprietors from their holdings in excess of the ceiling limit. Because there are two types of proprietors in the villages. Those at that time who had more land than the ceiling limit, which is applicable under the Ceiling Act, and the land which were taken from the proprietors, which fell within the ceiling limit. Now, the Honorable Supreme Court said in this judgment, State of Haryana versus Jai Singh, that this land, which was taken from their holdings, uh, which were in excess of ceiling limits, these have vested absolutely in the Gram Panchayat. Even if in the revenue record it is being described as Jumla Malkan Badigar Hakdaran, but in law, the ownership of these lands has vested absolutely in the Gram Panchayat. This is equivalent to the Shamlat. Same, Gram Panchayat has the complete ownership with this type of land. If, whatever be the description given in the Jamabandi. But those lands which were taken from the proprietors and which were within their ceiling limits, now these lands did not vest in the Gram Panchayat. This continued to vest in the proprietary body. But the important thing is control and management has vested in GP. Now the Gram Panchayat under this under section 23A of the Consolidation Act, the control and management has vested in the Gram Panchayat, and Gram Panchayat is fully authorized to make use of this land for the benefit of the village community. So that is the important thing. Now let us see that the relevant, firstly, paragraph of the Honorable Supreme Court decision. This is the para 23. Now this is para 23. Yes, can you see it? Yes.
Yes, sir.
Surbi, are you present?
Yes, sir.
Yes, Surbi, can you read this para 43?
Yes, sir.
Please read it.
The state of Haryana through Secretary to Government of
Niche,
Haryana.
para 43, not the
Okay,
upper.
sir. Okay, sir. Okay. A reading of the aforementioned judgments and the history of the Shamlat Day common land in the state of Punjab, including the state of Haryana, shows that the common land for the purposes of the present appeals falling in section 2G subclause 1 and subclause 6 of the 1961 Act as amended by the amending act can be broadly classified into three categories. Number 1, Shamla Day recorded in the ownership of the Gram Panchayat prior to consolidation, which vests unequivocally with the commencement of the Punjab and PEPSU Act. Number 2, land for the common purposes reserved during the process of consolidation by applying pro rata cut from holdings of the 371 proprietors, not necessarily falling within the permissible ceiling limits under the ceiling laws. Number 3, common purposes land reserved by the pro rata cut within the permissible limits as per the land ceiling laws, the management and so I can't read after this. There is no slide.
Yes. Can you read it now?
The management and the control of which vests with the panchayat. Para number
So
40. Should I read
no, that's all right, but that's all. Now there are three categories Supreme Court has now called out. Shamla and the um, Jumla, which is within the ceiling limit, and Jumla, which was taken from beyond, in excess of the ceiling, the three categories. Then now see para 48. Now the para 48. Thus, the property was held to be acquired as part of the agrarian reform under Article 31A, and no compensation was payable as provided in Article 31. Therefore, the acquisition was complete in respect of the land reserved for common purposes by applying pro rata cut on the land holding of the proprietors. Yes, thus we find in the middle, thus we find that the land falling in the second category, that is the land reserved for common purposes, not falling within the ceiling limit of the proprietor, would vest with panchayat. So this is now categorical finding by the Honorable Supreme Court that whatever has been taken from the proprietors would vest in the Gram Panchayat if this land was in excess of their ceiling limit. So such land even now in Punjab would be described in the land revenue record as Jumla Malkan, but the land would vest in the Gram Panchayat. Now thereafter we come to the third category. That is the lands which are within the ceiling limits. Para 63. Yes, Surbi, para 63. Yes, read it. Can you hear me? Awad.
Okay, so I'll just thus in the respect of the land taken from the proprietors from their permissible ceiling limits, it is the management and control alone which would vest with the panchayat. The management and control include leasing of land and use of land by non-proprietors, scheduled castes and scheduled tribes, etc., which is for the benefit of the village community. Therefore, vesting under Section 4 would be limited to management and control. It is pertinent to note here for that land taken from the proprietors by applying pro rata cut from the permissible ceiling limits of the proprietors, management and control alone vest with the panchayat, but such vesting of management and control is irreversible and the land would not revert to the proprietors for redistribution as the common purposes for which the land has been carved out not only include the present requirements but the future requirements as well. Such land would not be available for sale so as to confer title on the purchaser in view of the fact that the panchayat is not the full owner of the land, but while exercising control and management, it is duty bound to safeguard the land for the benefit of the village community.
That's all. Now see, now here one thing of importance which is to be noted is that before this judgment, the Punjab and Haryana High Court full bench decision, there was a concept of bachat land. So the Punjab and Haryana full bench had said that if this Jumla land, which vests in the Gram Panchayat management and control, if it is not earmarked, if this land, Jumla land, is not earmarked for any common purpose, This is important because this suits you still have on before you. For any common purpose, then such lands would revert back to the proprietors from whom it was taken. Now, this was the concept of bachat land. If the Jumla land is not earmarked for any common purpose, then such land would revert back to the owners from whom they were taken. Now, this concept of bachat land has been completely undone by the Honorable Supreme Court. The Honorable Supreme Court has now said that the vesting for the purpose of management and control is irreversible. Is irreversible. Even if it is not used for any common purpose. Yes, yes. Please unmute yourself. Please unmute yourself. हाँ देखना है आवाज़ आ रही है Yes, Mr. Paramveer Singh Kapurthala.
Hello.
Mr. Paramveer
Hello.
Singh Kapurthala, please unmute yourself.
Hello.
हाँ जी, please mute yourself. हाँ इतना नहीं हो सकता सर उतरते होगा जी मेरा हाँ जी the vesting of I was saying the vesting of property in the Gram Panchayat for the purpose of management control is irreversible. So the Honorable Supreme Court has said that even if it is not being earmarked or used for common purpose now, that doesn't mean that the
So you're not audible. So you're not audible.
So you are not audible, please.
Sir,
yes,
can't hear
I
you.
think am I audible now?
Right, sir. Absolutely right.
So the Honorable Supreme Court said that even if the property is not being used for the common purposes today, now, it can be so used in future. There is no such requirement that it must be used for common purpose now. Otherwise, it will go back to the proprietors. There's no concept of bachat land. If not used now, it can be used subsequently in future. But once the land is reserved for common purpose, it is irreversible. It will control and management. Shall keep on vesting in the Gram Panchayat. Any other proprietor of the village will have no right over management and control. And even though they have paper ownership, they are not entitled to alienate it, transfer it. No, you will see in some cases in Jamabandi, the land is Jumla Mushtarka Malkan. In the column of possession, some owner is shown to be in possession, cultivating possession. He makes a khanaka sale. He sells the land to a third person. Now, all those sales, rights transfer are impermissible. This is what the Honorable Supreme Court said, that after this land has the control and management has vested in the Gram Panchayat, no possessions can be transferred. Even the title cannot be transferred, even in relation to those lands which are within the permissible limits of the owners. So the vesting for purpose of management and control is final. Now we come to other aspect, that is the civil court jurisdiction in relation to these lands. Now the dispute with regard to these lands can be because some person may claim that he has interest or title in land described as Shamla or Jumla in the revenue record. Now he filed a suit in a civil court claiming interest or title in land described as Shamla or Jumla. Now, insofar as this Shamlat is concerned, the civil court jurisdiction is barred, clearly barred. Under section or by section 13 of the Punjab Village Common Land Act, and also in the Haryana Act, section 13, as applicable to Haryana. Shamla, there was never any dispute. If anybody claims a right or interest in Shamla, the jurisdiction of the civil court would stand clearly barred. But in regard to Jumla land, because section 13 said village common land as defined under the Village Common Land Act. Obviously, section 13 of the Village Common Land Act would apply to the Village Common Land Act property. So that was the interpretation. So the Punjab and Haryana High Court, in the case of Prakash Singh, Punjab and Haryana High Court, they held that section 13 will not apply to the lands described as Jumla Mushtarka Malkan. According to this judgment, if a person claims a right in the land described as Jumla, then civil court has the jurisdiction to decide this question. This is the Punjab and Haryana High Court view in Prakash Singh. Now, the Honorable Supreme Court has also set aside this view. The Honorable Supreme Court has now ruled that whether the land is described as Shamla or it is described as Jumla in the revenue record, in both cases, the land is a village common land, which is to be used for the benefit of the village community. Now this, the Honorable Supreme Court said, there is no distinction between Shamla simpliciter and Jumla insofar as the nature of the land is concerned. The nature of the land remains a village common land. which is to be used for the benefit of the village community. And therefore, even in cases of Jumla land, if a person claims any right or title or interest in such land and comes to the civil court by filing a suit saying, this has been wrongly described as Jumla. Actually, I have a right in this property. It is my property. He will have to go to the collector. That suit will be barred under Section 13 VCL. So Honorable Supreme Court has said that Section 13 VCL shall also apply to such lands. वापस ऊपर जाने वास्ते नहीं करना। So for this, I'd like you to read paragraph 54 of this judgment. Yes, who would like to read it? Para 54, yes. Samiksha, you read it because Surbi has already read a few. Samiksha.
So I can read it
Yes.
if you want. I can read it again.
Hmm?
So I can read it if you.
All right, go ahead, go ahead. Para 54, yes.
Para number 54. Still
Hmm.
further in charge saying it has been held that the forum available to a person who raises a dispute regarding title and Jumla Mushtarka Malkan
Is the
is the principal court of civil jurisdiction having jurisdiction in the matter as provided by Section 9 of the Code of Civil Procedure, that is a civil court. Though the said judgment is in the context of state of Punjab, but the said finding is not sustainable for the reason that Jumla Mushtarka Malkan is land reserved for common purposes during consolidation. Though Rule 16.2 of the 1949 rules prescribes that a common purposes land after applying pro rata cut would be described in the revenue record, but the expression Jumla Mushtarka Malkan or Mushtarka Malkan is a land of the proprietors for the benefit of the village community for common purposes. Therefore, if the revenue records as Jumla Mushtarka Malka or Mushtarka Malka in the ownership column, it is the authority under the 1961 Act and the machinery provided thereunder which would exercise jurisdiction to determine the dispute as to whether it is reserved for common purposes or not.
so Prakash Singh has been overridden. And the Honorable Supreme Court has said, even if it is Mushtarka Malkan land, under the authority under the 1961 Act, that is the collector under the Village Common Land Act, and the machinery provided thereunder, they would be determining the dispute with these lands also, in addition to the Shamlat lands. Then para 65 also, we'd like you to read.
Yes, sir.
Para, but it is not mentioned here in this. In para 65, the Honorable Supreme Court has held that if it is not correct to say that the land that is reserved for a particular common purpose can be used only for that very purpose. It can be used for any common purpose. This is also held in, I will give you another judgment. Two judgments I'll give you on this issue. So if you have a civil suit in which the prayer made is that the land user is being changed by the Gram Panchayat. So therefore issue an injunction. For that you have to keep in mind these two judgments. One is 2000 volume 6 SCC, page 84. This is the Sheesh Ram case. And para 65 in this judgment, which this is this judgment which I'm talking of today. This is reported in AIR 2022 Supreme Court, pages 1718. This is State of Haryana versus Jai Singh. Now, both these judgments say that Gram is you cannot say that the Gram Panchayat cannot make a change of user so long it is intended to be used for another common purpose. The Gram Panchayat can take that decision. But however, of course, as we know that merely because the Gram Panchayat has the authority to make a change of user does not mean that Gram Panchayat can act arbitrarily. Change power is there, but as you know, that existence of power does not mean that the power can be exercised arbitrarily. It is settled law of existence of power does not mean that it can be exercised arbitrarily. So why am I saying this? Because supposing you're closed with a civil suit in which the plaintiff says that the Gram Panchayat be restrained from making a change of user, then the Gram Panchayat comes up with this argument that it has been held by the Honorable Supreme Court in these two decisions that Gram Panchayat can use this for a different common purpose than for which it was initially reserved. You'll say, yes, you can do that, but but at the same time, you'll have to justify. You will have to show that you wish to make a change of user bona fide, in a bona fide manner. The purpose is laudable, bona fide, reasonable. There's no arbitrariness involved. There is no malice involved. The change of user can be allowed, but you have to show that it is being done for a good and valid reason. It is not being done arbitrarily. So there you will have to make your judicial discretion. You have to look into the facts of the case. You'll have to ask the company why you are doing it. Tell us what is the justification. And if they can satisfy you that they are doing it validly, not arbitrarily, for the genuine needs of the villagers, without causing any damage to the other needs of the village community, then of course they can do so. But what I wish to say is that one cannot, plaintiff just cannot succeed on this plea that the panchayat is making a change of user. That they can do. Of course, as I said, not arbitrarily, for a good and valid reason. So this also you have to keep in mind. Now, another issue which was decided in this case pertained to the situation where the land which is Jumla or Shamla, this came to be vested in this came to be transferred to the municipal corporation. ठीक है हाँ ठीक है ठीक इसको मिनिमाइज हो जाएगा ये इनमें हाँ जी ठीक हो Now, before that, I'll also wish to make another clarification that, as I said, that the land which was taken from the proprietors, which was within their ceiling limits, the Supreme Court has said in that category of lands would keep on vesting, ownership would keep on vesting in the Gram Panchayat, in the proprietors, and only the ownership and management, only the control and management would vest in the Panchayat. Then is there any practical purpose for this proposition? Does it have any consequence? Because Supreme Court has also said that the control and management is irreversible. There is no situation in which the control and management would come back to the proprietors. Is there any situation, can you think of any situation where this can have some meaning? Otherwise, this is only an ownership on paper ownership, which will never give any benefit to the proprietors. Proprietors can't transfer it. Proprietors cannot take possession of it. Proprietors in no eventuality will it revert back to them, whether the common purpose is being used for common purpose or not being used for common purpose. So can you think of any situation in which this distinction would have a meaning? Any situation in which this distinction can have a meaning? Yes, just apply your mind and tell me, can this have any meaning?
Sir, the panchayat cannot transfer ownership in the land.
In any case, yes, in any case, ownership by the transfer of ownership by the panchayat, as we read in the Supreme Court judgment also, that even a Jumla land can be transferred in favor of, for the benefit of SC, ST, etc. And moreover, in any case, the transfer of ownership by the panchayat is dependent on so many conditions. Panchayat cannot transfer the ownership at its sweet will. They have to seek permission of the government under the rules, etc. So yes, panchayat in any case cannot transfer the ownership of land at its sweet will. It has to be used for common purpose as per the rules and the schemes framed by the state. Anyway, yes, any other, the benefit which can accrue to the owners on account of this distinction, that is the question. The benefit which can accrue to the owner
Sir,
on
in case, sir, in case the land is to be acquired by the government, then under Article 300 capital A of the Constitution, the government has to pay the cost of the land to the proprietors. And in that case, the ownership concept can be of use.
Yes, what is your name? This is a good distinction you have made. Yes.
Vinod, sir.
And Vinod Sani.
Ji, sir.
Vinod ji, yes, excellent. Yes, that is Vinod is absolutely right and correct in saying that, because insofar as this land which was in excess of the ceiling, in that case, obviously the proprietors will have no right. Even if the land is acquired, the entire compensation will go to the panchayat. But where it is within the ceiling limit, the Honorable Supreme Court in this judgment has said that the ownership keeps on vesting in the proprietary body, and the panchayat only management and control. But once the land is acquired by the state, then obviously there is no question of management and control for the village community. Then the land goes to the acquiring authority. And the compensation has to be, the Supreme Court said in this very judgment that the management and control by the panchayat is on behalf of the proprietary body. It is a statutory control. It doesn't revert back, but it is on behalf of the proprietary body. And once the land is acquired, then the management and control by the panchayat loses all meaning. And in that event, the compensation will be payable to the proprietors. So that is distinction, and Vinod has correctly said that. Now let us come to the last aspect of this before I ask you last questions. This is regarding the inclusion of this area in the municipal limits. Now sometimes it happens that the Shamlat or the Jumla land gets included in the municipal limits. Then what happens? Now, this is of relevance because of the reason that in Suraj Bhan's case, ज़्यादा मोटा क्यों हो गया? That in Suraj Bhan's case, the 5-judge bench of the Punjab and Haryana High Court held. इन्हें देखना है जरा, इतना मोटा हो गया ज़्यादा. राइटिंग जरा बोल्ड हो गई. इसमें पता है क्यों हो गया. अच्छा ठीक, चल इस कर लो. ठीक. Now in Suraj Bhan's case, the 5-judge bench of the Punjab and Haryana Court held that insofar as Jumla land is concerned, if this is included in the municipal limits, it will its ownership would revert back to the proprietors. Ownership would revert back to the proprietors from whom it was taken. And it will not vest in the municipality concerned. And if the state wants it to vest in the municipality, they will have to pay compensation. So this was a major holding in Suraj Bhan. If Jumla land is included in the municipal limits, then they said it is no longer now a measure of agrarian reform. Therefore, the normal law would apply and the proprietors would be entitled to get this property back. Or if the state wants to keep this property to itself or to the municipality, it will have to pay compensation and acquire it according to law. Regarding Shamlat, also in Suraj Bhan, the view was that the Shamlat is of two types. One is which is the Shamlat simpliciter recorded in the Jamabandi, the Shamlat simpliciter. And the second was which is recorded in the Jamabandi as Shamlat De, Hasab Rasad, Zare Khevat, etc. So in Suraj Bhan, they said that this land, which is Shamlat simpliciter, would obviously, they say, would vest in the state, but this will go back to the proprietors. So this was the holding in Suraj Bhan. But now both these views of in Suraj Bhan have been reversed by the Honorable Supreme Court in this case, which I'm reading. So a few paragraphs on this also I'd like you to read. Paragraph. Yes, Survi, can you read 104? Hanji, can you hear me? Hanji. Yes. Vinod, can you read it? आवाज ही नहीं जा रही मेरे ख्याल आवाज नहीं गुड होगी
Para number 104.
हाँ जी हाँ जी प्लीज गो अहेड
Thus, if the whole or part of Gram Panchayat area is included in the municipal limits, the land reserved for common purposes as part of agrarian reforms would stand vested with the municipality. Such vesting is not a part of agrarian reforms but shall be on account of extension of municipal limits. When the municipal limits are extended, the residents of the panchayat also become residents of the municipality. The common purposes of the village community prior to extension of the municipal limits would be deemed to be common purposes for which land can be utilized by the municipality. Therefore, such vesting of land reserved for common purposes is not an acquisition for the first time, but transition of the land reserved for common purposes in the changed scenario when the land vests with the municipality.
So the Honorable Supreme Court says that again para 105 may also be read. Yes, Vinod. The argument, yes.
The argument of the proprietors that if whole of the Sabha area merges with the municipality, only then there can be vesting of land reserved for common purposes with the municipality is untenable. Such an argument would lead to anomalous results. The title right and interest of the property cannot be held in abeyance. There has to be continued control and management over the land reserved for common purposes under the 1914 88 Act. Therefore, even if a part of Sabha area is merged into the municipality will have control over the land so reserved for the erstwhile village community, which will now form part of the urban area. In view thereof, we do not find any merit in the argument raised on behalf of the proprietors and dismiss the writ petition filed by them while allowing the appeals of the state.
Para 106.
The
Yes.
The argument of the proprietors that the land which is not capable of being used for common purposes of the inhabitants of a particular village shall be reverted to the proprietors is untenable and unsustainable. The land has been put to common pool by applying pro rata cut. Once pro rata cut has been applied, the management and control of such land vests with the panchayat. There is no question of reverting the land to the proprietors. As discussed above, the land which is not part of the permissible limits under the land ceiling laws stand acquired and vested with the panchayat in terms of the judgment of this court in Ranjit Singh. However, in respect of the land forming part of permissible limits
Of the proprietor.
Of the proprietors under the land ceiling laws, the management and control vest with the panchayat. Neither the 1961 Act nor the 1948 Act contemplates redistribution of land to the proprietors. It is an irrevocable act which cannot be undone. Therefore, once land vests with the panchayat, it can be used for common purposes of the community and will never revert back to the proprietors.
So now in a nutshell, what we have seen in the impact of the judgment of the Honorable Supreme Court in this case, Jai Singh's case. Now the impact is clear. One, that if the land, Jumla land is from that portion of land which is in excess of the ceiling, if it is in excess of ceiling, if the Jumla is taken from a landowner and it was in excess of his ceiling limit, it vests in Gram Panchayat. Ownership vests in Gram Panchayat. This is clear. Two, if it is within the ceiling, then ownership remains in the proprietary body. Management and control vests in Gram Panchayat. But this vesting is irreversible. under no circumstance it will revert back. This is to the only relevance it can have is on acquisition. Otherwise, it has no relevance. This is one thing that has been held. Number two, there is no concept of bachat land. ये बहुत बड़ा हो गया. So even if land is not being used for common purposes, or it is not earmarked for common purposes, it will not revert back to the, no, it will never not revert back to the proprietors. This vesting in Gram Panchayat, even though only for management control, is irreversible. This is one thing. Then the next point that has been held in this judgment, that even in the case of Jumla land, if any right or title is claimed therein, the person so claiming shall have to go to the collector under the Punjab Village Common Land Act, Section 11 in Punjab, Section 13A in Haryana. The jurisdiction of the civil court would be barred under Section 13 of the VCL. So the civil court has no jurisdiction now in relation to declaring a right, title, or interest of any person in Shamla or in Jumla. So Prakash Singh judgment has been overruled. Then the next point is that if there is a change of user, Panchayat has the power to make a change of user. It need not be confined only to, you cannot force the Panchayat to use the land only for the purpose for which it was initially earmarked. The user can be changed, of course, not arbitrarily, as I said. It must be for good and valid reasons. Then the next point that has been settled is even on inclusion of such lands within the municipal area, the nature will not change. If the management control vested in the Gram Panchayat, within the ceiling land, it will now come to vest in the municipality. Those properties, ownership of which vested in the Gram Panchayat would now vest in the municipality. Suraj Bhan has been overruled. Concept of bachat land has been completely undone. Civil court jurisdiction has been ousted, even in relation to Jumla. And so this is in a nutshell, the holding in this judgment. Now, next session would be, but before that, a few questions, one or two questions we can take, because then the next session would be important judgments by Madam Karunaji. Yes, a couple of questions you can. Normal. बंद कर. Yes, if you have any question, one or two questions we can take, then anyone has a doubt or want some question. Yes. No questions? Yes, Harjot, how are you?
Good afternoon, sir. I'm fine, sir.
No questions, Harjot?
No questions, sir.
All right. All right, then, if you have no questions, we can. All right.